Adjournment request, if any, from item number 1 to 14.
Lordship, item 1 to 4, Lordship. Lordship, we prepared the affidavit and have sent it for vetting. Lordship may grant us 1 week time, Lordship, we'll find the affidavit in the meantime, Lordship.
On behalf of whom?
Lordship, on behalf of GMC, Lordship. GMC, Lordship, we already, Lordship, regarding the work order and as to
What happened?
the service provider.
Waiting for the Mr. Nayak was appearing.
Lordship, I'm appealing on his behalf, Lordship. Lordship will file the affidavit within a week, Lordship.
Last time also you took time.
Lordship, it has been sent for vetting, Lordship.
Monday,
Affidavit is
Monday.
prepared. Monday, Lordship, deeply obliged, Lordship.
May I please, your Lordship? Lordship, with the consent of the other party, I beg to mention item number 11, as my senior is out of station, Lordship.
11 and 12.
Including party respondent.
Yes, Lordship. We have filed an IA for implementation of new party.
Sajja.
Deeply obliged.
Yes.
From item number 16 to 25.
Item number 17, I filed an affidavit yesterday, my lord, that may be called from, it's already filed. Deep level. May please, your lordship. Lordship, I beg to mention item number 18, your lordship. We need some time in the matter.
Why?
The lordship had posed a query on the earlier occasion. The records have just recently come to assess this honorable court, your lordship.
What query?
The fact that whether the witnesses were examined during the departmental proceeding or not. There's a voluminous records have come, your lordship, to assess this honorable court. If your lordship can kindly grant us a week's time.
After a week.
I'm grateful, your lordship.
May I please, Lordship? Lordship, with the consent of the other side, Lordship, I beg to mention item number 20, Lordship. Lordship, 2 weeks' time may be granted, Lordship, for filing the reply, Lordship.
For filing,
The reply, Lordship.
you are on behalf of the state.
No, Lordship, for the appellant's, Lordship, petitioner, Lordship.
2 weeks.
Would be obliged, Lordship.
Yes.
May I please, Your Lordship? With a concern from other side, I beg to mention item number 41, Your Lordship. My senior have some difficulties, Your Lordship.
41.
Your Lordship, one week may be granted, Your Lordship.
2 weeks.
Much of that.
May I please, Lordship? Item number 29, Lordship.
29.
I need little accommodation for today, Lordship. For today, Lordship, I will take consent of the other party, Lordship.
I
appear for the appellant. A record is needed, Lordship, in this case. The order is single bench, order was passed by the ongoing to the record, Lordship. I'm like,
Next week, if possible. Next week, if possible.
2 weeks.
May please, Lordship, I beg to mention item number 48. May kindly be adjourned for 1 week.
48.
For 48. There is a problem. I am also under treatment, and my client also suffering from illness. I could not file the Contempt petition already ready. Your Lordship, may kindly be only 1 week. Adjournment.
2 weeks.
Master, I shall inform the other side.
Maybe Your Lordship, under item 42 to 46, we have taken consent on the other side. Lordship, the council who assists the learned advocate general is in bereavement, Lordship. If I prefer,
Consent?
the council assisting the learned advocate general, Lordship, is in bereavement. Therefore, Lordship, 2 weeks' time will be granted, Lordship.
The last occasion we directed you to
Lordship,
complete your instructions
Lordship.
regarding grant of ACP to.
Lordship, the council, Lordship, as per, I have been informed, she had communicated, but Lordship, since she is in bereavement, Lordship, she could not, Lordship, she was doing the instruction.
How much time?
Lordship, 2 weeks time will be granted, Lordship.
2 weeks. Yes.
But item number 34, the last occasion Lordship has directed us to place, my lord, the reports from all the districts of the state. Whether, my lord, there is any quack doctors, my lord, who are practicing. 2 affidavits we have filed, my lord. The latest instruction is awaited, my lord. I pray for further 2 weeks time, my lord, or 3 weeks, my lord. Two affidavits we have filed. Lord.
Who is for the other side?
My lord, I've taken consent from the other side. From the senior counsel, my lord, I should is there, my lord. I've taken consent.
2 weeks,
He is appearing, my lord. After 3 weeks, my lord.
3 weeks.
My lord. I am obliged, my lord.
May I please, your lordship? Lordship, item number 21, I am making a prayer on behalf of the petitioner in person, my lord.
Why?
My lord, he is out of station, my lord, today, my lord. We have to file our affidavit in reply, my lord, to the counter affidavit filed by the respondent.
It is in relation to that entry of.
Yes, my lord, yes, yes, yes.
2 weeks.
My lord. Obliged, my lord.
Please, your lordship. Actually, with the consent of the other side, I beg to mention item number 35. The matter may come after a week, lordship.
5
35, lordship.
PIN.
Yeah, lordship.
You are for?
Lordship, I am for the petitioner, lordship.
You have certain problems in this petition. You are seeking termination of those employees whose services have been regularized. You are not made party to them. And how a PIS in service matter is maintainable.
Lordship, here I have challenged the process, lordship, the process.
Yeah.
Yeah, because they have not followed the proper procedure.
Ultimately, you are seeking this.
And we are
that,
seeking an
their services
inquiry,
should be
lordship, for
terminated,
that.
They should be discontinued, the persons who have been regularized. Ultimately, it's a service matter.
Lordship, may please give me 1 week next week, because today, lordship, it escaped my notice, so lordship.
1 week.
Applies.
May please, your lordship. My lord, I pray for the listing of item in the motion column day after tomorrow, my lord. This is the writ petition. I'm obliged.
Any other request?
May I please, your lordship? Lordship, I beg to mention for listing on WA. It may come up for order.
Why orders? It is already pending,
It was supposed to be,
pending matter.
yeah, it was supposed to be listed after 3 weeks. But it's not listed.
Let's see.
Daily list for orders item 5.
We have taken step, madam. The respondent has appeared, madam.
Lordship, we have received the notice from this honorable and today I got the color number, lordship. I will file the color number
On behalf of whom?
on behalf of the private respondent, respondent number 5.
Respondent number 5.
Yes,
Okay. Mr. So and so put in appearance on behalf of the respondent number 5. So this is therefore complete. This writ appeal, list the connected with appeal for admission after 2 weeks. Completely.
Highly obliged.
Item 6.
April 24 order, your lordship directed for payment of arrear and current salaries. They have paid about 60% of the salaries. That means respondent number 1 has already received it.
This is where it should be.
So now what do you want?
No, this the salary, the order has not been completed, complied with.
So you're not get the notice served upon respondent number 2 to 6.
Not respondent number 2 and 4 may not complete. Respondent number 1, he has already paid the amount. Half of the amount he has paid.
Acha, 1 and 6.
Yes,
The service upon the respondent number.
I think the government advocate can help, my lord, because they have already received the amount.
Yes. Which is the department?
Education department, the secretary government of Assam. They paid about 50% or 60% of them. Content to retake instruction. Content to- Payment detail. Above the start of the current salary.
Yes.
She would have it, escape my notice, my lord,
You are
Monday.
appealing.
My lord,
You are appealing.
I'll take my instructions from the department. Since
Like, Mr. Armajimda, put in appearance on behalf of the respondent number 1 and 3. Other respondents have already been served. Mr. Majumdar seeks some time to furnish the factual report regarding the compliance of the order filed by this court. List after 2 weeks.
oblige.
Item 7.
Please, your lordship, my lord, I have entered appearance on behalf of the respondents 2 to 7. I need to file a reply.
Respondent number 2 to 6.
2 to 6.
You are appealing.
Wakalatnama is only, has come only from 7, but the respondents are all the official respondents of IWAI.
So you are appealing.
Yes, but some time may be granted, my lord, we will be filing a reply.
Delay confirmation.
That is the instruction, my lord, that I have received.
Yeah, Mr. Espani. Sorry. Mr. Esther, put an appearance on behalf of respondent number, all the respondent number 2 to 7. 2 to 7. Who is appearing?
I'm for one.
Yes, so and so is appearing on behalf of the respondent number 1. Service is therefore complete. Mr. Datta, place some time to file objection to the condonation application. List after 2 weeks.
Item 8.
Make me not.
Respondent number 6, you are.
My lord, I appear for the respondent number 6.
What do you want to say?
My lord, I want to file an objection, but before that, my lord, the present appellant, which has he has challenged the order of the learned single judge, my lord, he was never a party in that writ petition, my lord.
He was not a party.
Yes, my lord, but before filing this writ appeal, he should have filed an leave of, yes, my lord, he should have filed a leave of.
Without leave,
My lord,
how can you?
my lord, I am filing my lord, sometime a weekend. my lord.
Make it. This IA comes upon for consideration of the application under section 5, the limitation act, with the prayer to condone the delay of 48 days in filing the connected appeal. Stop. Mr. So and so put in appearance on behalf of the respondent number 6 and has submitted that. As a matter of fact, the applicant was not party respondent before the writ court, whose against whose order the connected writ appeal is filed. It is also submitted that the applicant has not filed any application seeking leave from this court to file appeal against the impugned order. At this stage, let me counsel for the applicant raised for and granted trying to move appropriate application seeking leave to file against the impugned order passed by the learned single judge. Rest after 2 weeks.
Oblige.
Item 9.
May I please, Lordship? Lordship, in the last order, we were directed to take
Take
steps.
steps.
Yes, however, inadvertently, we couldn't take steps due to some difficulties. Therefore, Lordship, please grant us 3 days' time to take steps.
You have to satisfy that how you can file an writ appeal against the order passed by the learned single judge while exercising jurisdiction article under Article 227. No, it's not an order under Article 226.
Lordship, it was a delay condemnation. We couldn't take.
No, it may be condemnation, but he just satisfied, will condone the delay, but what's the point in condoning the delay when the this writ appeal itself is not maintainable?
Lordship, grant us some time to take.
The matter comes upon for consideration of the present IAC condonation of 580, how many days? 584 days. 584 days in filing connected appeal. For condoning, they delay in filing the application for restoring the writ appeal number 8246/2024. On last occasion, learned counsel for the applicant was directed to take steps for service of notice upon the unserved respondents. However, no steps have been taken till date. It is to be noticed that the writ appeal, the writ appeal which was dismissed in default was preferred against the judgment passed by the learned single judge dated 12/2/2016 in writ petition numbers 79 and 80 of 2012 at Isol bench. Which from the perusal of the order dated 12/2/2016, it appears that the writ petitions, that the writ petitions number 79 and 80 of 2012 were allowed by the learned single judge while exercising jurisdiction under Article 227 of the Constitution of India. Stop. Prima facie, we have the view that against the order passed by the learned single judge while exercising jurisdiction under Article 227 of the Constitution of India, writ appeal is not maintainable. The writ appeal, which is sought to be revived, is not maintainable. Learned counsel for the applicant plays some time to satisfy this court regarding the maintainability of the writ appeal, which is sought to be revived. Just after
Any date,
4 weeks.
highly obliged.
Item 10.
As per office report, my lord, this.
You are appealing for?
Respond number 1 and 2.
Four is unserved, my lord. Four is unserved, and rest of my lord, no report has come, my lord. So I will be allowed to take papers.
You are appealing for 1 and 4,
1 and 2.
1 and 2. And rest are not also not. Fourth is also.
Four are not unserved, my lord, rest of them, no report.
Four is received answered and
I will take a paper, not paper for this one.
okay. Mr.
Yes, came in.
So and so put in appearance on behalf of the respondent number 1 and 2. As per the office report, notice issued to the respondent number 3, 5, 6, 7, and 8 has not been returned till date. Whereas the notices issued to the respondent number 4 remains unserved. Full stop. let notices issued to the respondent number 3, 5, 6, 7, and 8 be awaited for 3 more weeks. In the meantime, the respondent of the counsel for the applicant may take steps for notice, take a step for service of fresh notice upon the respondent number 4. Requisites be filed within a period of 1 week, returnable 2 weeks thereafter.
Well, for paper publication, it is better because
Paper publication, let first notices.
yes.
Obliged.
Directly by paper publication. Yes.
Item 13.
Appeal has not been admitted as yet, my lord. No notice has been issued also, my lord.
But the matter comes upon for consideration of stay application.
For admission, my, yes, stay,
application.
stay application.
What do you want to say on stay application?
Yes. What is up, in this case, what has been, my lord, initially, way back in 2099, my lord, and when 145 proceeding, where the position was declared in my favor, my lord. And thereafter, he preferred a civil suit, my lord, against that order. He preferred a revision before the session judge, that was rejected. Before the High Court also, it was rejected. Then he preferred a session, before the civil court also. That was also, injunction petition was rejected, my lord. Now, what happened in the meantime, as DCM directed an order, passed an order, which was challenging the writ proceeding, were directing him to give position to me, madam. And that was challenging the writ proceeding, madam. And that order was set aside, madam.
What's wrong in that order?
No, no, I'm not, but last portion of that order, my lord, that is creating a problem.
Yeah.
That you will also may kindly come to the impugned order, my lord. That page 97, my lord.
Yes.
Because from 96, you will also find where the learned single judge has already held that respondent number 5 is in position, my lord. From materials on record, issue consideration whether the impugned order could have been passed by respondent number 3, thereby directing respondent number 4 to hand over position to respondent number 5, where in order dated 22/8/2001, there was no direction by respondent number 3 to hand over position. Materials on record discussed herein above clearly show that petitioner has filed the proceeding MR case number so and so. Said proceeding culminated with the order passed by learned executive magistrate declaring position in favor of respondent number 5 until evicted due course of law. A tenor order therefore cannot be assumed that respondent number 5 was in possession of the disputed land. However, respondent has not filed an application thereby seeking initiation of proceeding under the provision of 145 to the effect that petitioner has been dispossessed the respondent number 5. That actually it is not correct, man. It should be petitioner, madam.
No.
However, the respondent has not filed any application seeking initiation of proceedings under the section 132 to the effect that petitioner has disposed of respondent number 5. It is apparent that on perusal of 145 CRPC, said proceeding has initiated within 2 months from the date of when person is disposed forcefully and wrongfully disposed. Under such it is therefore opinion of the court. Respondent could not have directed respondent number 4 restore the position to respondent number 5 on the basis of the order so and so. Consequently, impugned order set aside. But now your lordship will kindly last paragraph number 13. However, liberty is given to respondent 5 to agree to proceed in accordance with law seeking eviction of the petitioner. So petitioner was never in position, my lord. That is the creating term. Now, what has happened? In person of this order, he filed an application before the OC, my lord, that I'm in position. She wants to totally forcibly take position, my lord. Since order was given in my favor by the
Now, this is the case that the petition doesn't have to be. He was if he was in position, what is then he should be now required in the direction. नहीं, position में तो नहीं। Voting में है, level पे तो voting conflict. दो points are बीच में.
My lord, in 1999, in 2001, my lord, possession is declared in his favor. So if he is in possession in 2001, my lord, where the question comes of giving him back possession in 2008, my lord, or subsequently by the impugned order, the order which was impugned in the writ petition, my lord. If he is in possession in 2001,
Present, who is in position?
I am in possession, my lord.
Not in position. How you came into position?
My lord,
When the-
I was always in possession, my lord.
Declaration was there that he is in position. How you came into position?
I was in possession right from the beginning, my lord. That is my case. Now, even if he is in possession, my lord, by means of a 145 proceeding, my lord, possession was declared, no difficulty.
Position was declared that certainly he was in position.
But now, my lord, I am in
And
possession.
your challenge to those that order that have already been dismissed.
No, my lord, the order subsequently passed directing the police to hand over possession. That was under challenge, my lord.
One 45. It says that initial proceeding was, he says that he had freedom of the public proceedings because he is felon of the because he declared in position appellant. And it is that he signed the then what happens in terms of that the subdivision under this proposition? Also in terms of these subdivision in terms of the first order, not under our nature, this position only happening
Maintain a status quo to penalty.
Yes.
The matter comes upon for consideration of the IE number 2. They pray to. This, with a prayer to. Restraining the respondent number 5 from taking possession of the disputed land measuring 1 biga covered by the number 22 of annual patta number 38 of Moza, Lumding in the district of Hojai, or to pass an order for maintaining status quo till disposal of the property. Having heard the learned counsel for the parties and after taking into consideration that both the parties are claiming possession over the land in question, as on today, we deem it appropriate to direct the parties to maintain status quo as it exists today till final disposal of the writ appeal number 264 of the 2024.
Status quo as regards possession, my lord.
Status quo as it exists today, whatever possession record or whatever. IE number so and so is restored.
Lordship has admitted the appeal, my lord. The appeal.
Appeal, whenever it will come, I will admit it. Today, appeal is not listed for admission.
Item 14.
First time.
First time it is listed.
First time lordship. Learned friend, he is appearing as for the petitioner in the writ petition. I have the talk with him, he can appear.
The respondent is there.
But only one.
One.
My lord, I just at a glance, there's no explanation at paragraph 8 about what caused the delay. There is not a single word,
Union of India,
Union of India. It simply says
On-
we
not
to,
supposed to. They are above the law.
not a
They are
single
not
word. my
supposed
lord.
to disclose.
Have they said postal delay, anything, not a single word? We took time to take a
This is
decision.
procedural,
117 days.
procedural delay that is to,
Nothing there.
that we have to obtain consent from other departments, higher
On which
authorities.
date you send that, and
Exactly.
on which date you
That-
receive that consent, you please mention it.
Lordship, we have stated, but exactly, we have stated
Exact
that,
dates. Dates.
but it's only 119 days. It's not such an inordinate delay. It's not there, Lordship.
One day you have to explain,
Lordship, but
when if there is a 1 day delay,
But
and
it's-
the, as being an union of India, responsibility is much.
Lordship, but,
You can't take it for granted, since Union of India is there, we may file appeal at any point of time.
Lordship, but, recently it held that, day to day may not be necessary in all cases, Lordship, when it is not an inordinate delay, Lordship.
So
For an MSCB benefit, my lord.
Let us see. The matter comes upon for consideration of the IA number so and so, with the prayer to condone the delay of 119, 20 days in filing the connected writ appeals. All these IAs are for condonation of delay.
No, one is, for stay of the order also.
IA number 3122/2024 with the prayer to condone the delay of 120 days in filing the appeal. Mr. So I'm assuming that put an appointment on behalf of this whole respondent. Stop. He has opposed the application for condonation of delay by saying that the applicants have not sufficiently explained the delay filing the connected writ appeal. Having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate to condone the delay of 120 days in filing the connected appeal. Hence, IA number so and so is allowed. Delay of 120 days in filing the connected writ appeal is condoned. Registry is directed to register the connected writ appeal and display before this court for admission after 3 weeks.
Much obliged.
Item 15.
but there is a delay of 117 days, we have to define the appeal.
Notice. Returnable 5 weeks. Yes.
For admission, item 16.
May future. Earlier, your lordship has directed us to file a detailed affidavit concerning the.
Yes.
So yesterday we have filed it. Perhaps it has not connected with this, with your lordship file. May I pray that it may come next week?
Next week.
Obliged.
Item 17.
Item 17, they filed a short affidavit yesterday, your lordship. May I pray the matter may come up on Friday, your lordship.
Lordship, in this case, I have been instructed to appear on behalf of respondent number 3. NC Hills Autonomous Council. So I received all the papers yesterday. I need 1 week's time, Lordship. So that if necessary, I'll also file a very short affidavit.
Short affidavit is filed on behalf of whom?
We have respondent number 1, your lord. Respondent number 1. your lord.
No notice was issued in this case till now. On the maintainability point also, I would like to raise this objection.
Okay, Mr. Lee Sekia. The objection regarding the affidavit raising preliminary objection regarding the maintainability of the writ petition is filed on behalf of the respondent number one. You have filed today.
Yes, sir. Yes, sir.
Over the said affidavit is not available on record.
It has come. It has come.
It has come. Learned counsel appearing for the. Yeah, nothing, not come on record. Learned counsel appearing for the petitioner fails some time to file counter to the affidavit on behalf of the respondent number one. Mr. D. Sekia put in appearance on behalf of the respondent number three. Has placed some time to file counter to the petition. List on when?
Next week, Your Honor.
Yes,
Fourth of November, Lordship.
it's on 4th of November.
Lordship. Only instead of lordship, it could be liberty lordship because you have to serve a copy to a client, your lordship. In case they do not wish to file a counter to the same lordship may just grant the liberty to file an affidavit in reply to that.
And it's always there, we are not restricted.
Lordship.
Highly obliged, Lord.
Item 19.
This is the petition filed by the department against the order passed by the learned CC. Where if highest scale was granted to the respondent.
4,800.
Yes, sir, but he is not entitled to that. Now our rule also doesn't provide for that. But since the respondent appears.
पर इनका रूल्स सपोर्ट नहीं कर रहा और यहाँ पे सर एक चीज क्लियर नहीं है whether the earlier decision of the is open relating to a similar central government organization.
Yes, ma'am. Lordship, we have filed, or we have already filed the affidavit in opposition, Lordship. So we pray for fixing of hearing next day.
It appears that when there is no great pay of 4,800, how the government can issue a direction to grant them great pay of 4,800? You may be entitled for that higher pay scale, but whether it is to be 4,800 or something else.
We have already recorded 24.
Is a counter affidavit?
They have filed counter affidavit.
Page 30. We like in the junior translator, we have words of the copy of the description being published.
This, what is the appeal is? This petition is filed on behalf of the appellants, challenging the order passed by the tribunal whereby the CAT Guwahati whereby the direction is issued to the respondents to grant the applicant grade pay of rupees 4,800 from 29/1/2010. Full stop. Then the concept of the appellant has submitted that as a matter of fact, in the Central Board of Direct Taxes in bracket attached and subordinate officer bracket close, senior translator in bracket group B non-gazetted / non-gazetted, non-ministerial post bracket close, recruitment rules 2018. There is no grade pay of rupees 4,800 for the post of senior MD translator. Full stop. It is contended that when there is no grade pay prescribed in the rules, the tribunal has added directing the petitioner to fix the respondent in the said grade pay, which is not available. Stop. Counter to the petition is filed on behalf of the where it is submitted that the tribunal has committed no illegality in directing the petitioners to fix the petitioner to fix the respondent in the grade pay of rupees 4,800. Stop. Para. Having heard the learned counsel of the party, we are of the view that matter requires consideration, hence admit no need to issue notice as parties are represented through their, as all the parties are represented through their counsels. In the meantime, till the pendency of this petition, the impugned order passed by the tribunal shall remain. Impugned order passed by the tribunal in original application number 344 of 2017, dated 14th of March 2019 shall remain stay.
Much appreciated.
That was in case of, that was in application of an OMB.
So Kyle, do one thing, in the meantime, you file the OA and reply filed on behalf of.
We have already filed Lordship by OA Lordship by additional affidavit.
When, not on record. And the OA, and the OA dated 13/12/2009.
I'll file again Lordship.
13/11.
13/11/2009.
Lordship.
Item 22.
No.
Yes.
May please your Lordship. My Lord, record of tenancy case number 66 of 95 has to come from the Deputy Commissioner Kamrup Metro Lordships. Accordingly,
That record on the last occasion.
Was produced 25/6. Madam.
I had talked with they are saying that this record is not available.
So where it is now?
They are starting back the power.
So what to do?
Maybe, okay, that will be put.
Will you go
Well, the record of the disability is not necessary for disposal of this rate appeal.
But earlier we have observed, because the court has called for that record. Because what we remember that on the last occasion, There was a plea on
My
behalf of
learned
the,
friend paid for time for producing the record.
there was a plea on behalf of the this petitioners or appellants that their name in this that record royalty case number 66 of 1995. And you have to produce the record, whatever it may be. File an affidavit. Why this record is not available? File an affidavit. Okay. This court wide order dated
I don't know what people record as a.
29/11/2023 directed the respondents to call for the records of royalty case number 66/1995 from the office of the Deputy Commissioner Kamru. Despite granting several opportunities to the Government Advocate Assam, the record has not been produced till date. It is submitted by Mrs. R.D. Bora. That record is not traceable. Stop. Once the record of the lower court is called from called, the same has to be produced before this court. Stop. The District Commissioner Kamdu shall file an affidavit by the next date of hearing that why the record called for by this court has not been produced and why it has not been traced till date. Next, after 3 weeks, file an affidavit.
Lordship, interim order passed earlier may continue.
Yeah.
Interim order passed earlier may be.
Interim order, if any, to continue till next week. Now the record will come. Once we have asked them to file an affidavit, the record will come.
Item 23 to 27.
Make with your lordship.
There are some developments actually.
Developments.
Yes, yes.
Yeah.
But the petitioner's grievances is that their land have been taken over by the government for construction of some college and whatnot. Now, that question is whether it has been relinquished by us, that is the issue. But now probably government has changed its mind. They want to provide, we are all cultivators. They want to provide us alternative lands. The issue is going on. If that is the case, lordship, our purpose will be served. We are basically cultivators. Land is the only livelihood.
In fact, my lord, before the almost single judge, before the final disposal, there was an interim order directing the state to find out any alternative land. They have been offered land. Some of them have also agreed also to take. But one or two, there are quite a few parties, my lord. One or two are only opposing. Others have agreed to take. And they wanted agricultural land. We, from our side, we have given agricultural land. So they want some more time because some more interactions are going on.
Recently, they have contacted the client, the people, that they want to, they are still proposing to offer us alternative lands, cultivable lands, and we are agreeable to that. If that is the case, lordship, land is our only livelihood.
Because 39% of the construction before the single judge, my lord, it was,
That is already.
yes. An amount, about 20% of the amount was already paid to the contractor. And the writ petition where the contractor was a party, against that, there is no writ appeal till now. Writ appeals have been filed in respect of others where the contractor was not a party. Anyway, my lord, if they are offered land and if they accept, matter can be disposed of in that direction.
Yeah. The writ appellants challenge as approved the report.
I'll pray before lordship that
As opposed the writ against the action of the state government of acquiring their land Is there agriculture land for the purpose of construction of a medical college?
No, model degree college.
Model degree college. Full stop. The learned single judge has non-suited the appellants while recording a finding of fact that the appellants have relinquished their agriculture land voluntarily by executing relinquishment deed. Full stop. But the appellants have challenged the impugned order passed by the learned single judge while claiming that they have not relinquished their land voluntarily and has also argued that and are also contending that the relinquished deeds are forced. You are
Yes.
the
That is it.
relinquished deeds are forced. Stop. Para. Today, learned counsel for the parties have submitted that though a proposal was given to the appellants before the learned single judge by the state government to allot them alternative agriculture land in lieu of the land acquired by the state for the purpose of construction of college. Full stop. At that, before the learned single judge, some of the appellants have agreed, but some have not agreed, and therefore the said proposal could not be carried forward. Full stop. Learned counsel for the appellants as well as the learned additional advocate general has today submitted that now negotiations are going on between the state as well as the appellants. And principally the appellants are agreed for alternate land and therefore the matter may be adjourned for completing the negotiation between the appellants and the state. Stop. In view of the above submission made by the counsel for the parties, is this matter after 6 weeks?
Let it be two months. In the meantime, they will proceed.
8 weeks. There was a proposal on behalf of the state government that will provide you land before the landed single judge.
No, London Single directed that you may explore the possibility. And in one of the cases, my lord,
Okay. Before the single judge name, during the petition, the issue a direction to the respondent state to work out whether and the alternative agriculture land can be allotted to the appellants or not. However, they said that action could not be materialized on a point for because some of the appellants not agree to are not agree. We'll change them.
my lord,
Oblige you.
Item 28,
May I please address? Since I had filed affidavit reply against the affidavit filed by Respondent 1 and 2, it is not on record. Let this case along with this affidavit and reply.
Stay vacation application.
No, yeah.
Actually, you have filed an affidavit in reply.
Already I have filed, it is not in this. Today I have filed.
Now, who is running this?
Applicant
Yes,
and- applicant-
you are at present, you are operating.
Operating it.
Okay, something very quickly. If someone has the point go ahead. Do. Second, the doctor of the left side of the right, so be as some. Effective rotation of the body. So when you cannot.
In that Dayaljan ball, there is a stay by the Supreme Court or something.
Lordship. The similar nature of the order I have NA, it is subsequent order.
Yeah.
Recent order, your lordship. Yeah. Thank you.
Who is this here?
It's got I have annexed.
Yeah, next.
In the appellant, I have annexed
The appeal.
in appeal, case 213.
2-1.
3, Your Lord.
Will admit it. Will admit the petition. Will hear in the report. Having heard the learned counsel for the party that left, we deem it appropriate to. We are of the view that matter requires consideration, hence admit. No need to issue notice as parties are already represented through their respective counsel. Interim order passed by this court. On 21/6/2024 shall remain in currency till pendency of this writ appeal.
Obeisance.
Listing reports. Yes, next.
Item 30.
May it please, Your Lordship. So here also I am appealing for the response number 7, Lordship. I paid for little accommodation to file affidavit, Lordship.
Selection. Selection. So, इसका खाली सब ये निकाल देने वो खाली डेट को बता दें.
Yes. Here also I am appealing for the response number 7, Lordship. I pray for some time to file affidavit. It's getting ready, Lord.
Mr. So for the appearance on behalf of the respondent number 7, please some time to file. Counter to the writ appeal. Just after 3 weeks.
Obliged.
I'm obliged. Item 31.
May it please the lordships. My lord, for the elections of a particular cooperative society, some people had withdrawn the nominations, some rejected, and 9 were accepted. Since the total number of posts of directors were 15, those 9 who were accepted were declared uncontested. 7 are before your lordship. On the ground, those out of those who were rejected, they had assailed that. Their specific plea was, there's a requirement that you have to attend 2 meetings in the previous 5 years. All right.
What's the wrong in the order of the?
I'm
registrar?
approaching.
Since the record is not available, so you can't ascertain and you can't now disqualify.
I'll address on
since
that.
you are not,
On their first brush, it appears, okay, records are not available equal for all. So 3 years were there for all, 2 for none. And they took advantage to say that if I may put it that way, that since there is not there, it's not in our custody, you lost it. So therefore, give the benefit to us. Very good. But this is in conflict with section 80 of the Act.
How?
If my lord may have section 80 of the that's that. What happens when documents are not there? Or where do I find those documents? Is it only the list of registrar? They thought very far, but we kept it to the next level. Section 80, you know,
Section
80 of the Act.
accounts, records and.
May I read?
Yeah.
Every cooperative society shall keep at its head office the following accounts, records, and documents, namely, I invite my lord's attention to I. A list of a list of members, their fulfillment of responsibilities over the previous financial year, their eligibility to exercise their rights for the current 12 months period, updated within 60 months of the closure of the cooperative year. I pause, meaning thereby, once the cooperative year closes, 60 days therefrom, there's a requirement of law, update the eligibility. Therefore, over and above, beyond that register, there has to be a document and exercise carried out, number one.
Whether that is in existence or not.
Perfectly, because it was lost admittedly on 1st of February 2023, and this has to be carried out in November. So the exercise was carried out. This fact lost. This was not taken into consideration ever in all sort of proceedings, number one. That's the only clause, because there has to be a document over and above the register. And when the register was present for those 2 years in the month of, say, October, November 22, then the exercise had to be done. The eligibility was there.
That record is there or not?
It has to be with the authorities, my lord. It has to be. Otherwise, the notice would not have come.
Otherwise, that particular instruction I have to obtain it because day before yesterday I have received the extra copies and I have sent it to the department, Your Lordship.
Bring the record.
Yes, Your Lord.
Bring the record.
Yes, Your Lord.
From there, it could be ascertained whether they
Yes, sir.
attended the
It can be
meeting or
ascertained.
not.
Yeah, absolutely. In the meantime, I pray for an internal protection measure. Otherwise, everything goes. Let it as soon as possible. As soon as possible. Tomorrow, day after tomorrow, the day after tomorrow. Monday, my lord. Absolutely. A protection till then, my lord. They may not proceed.
Protection.
They may not proceed, my lord. A word from your lordship matters, my lord. They may not proceed.
My lord, already there is an order in the, even the order, my lord, subject to the outcome of the, my lord.
Correct. The interim order would be considered now.
Where is that?
So, you have ordered it in 10.
In the last, sorry, last order, my lord. In the last order, my lord.
There is also an observation that the interim would be considered today, my lord. They may not proceed.
When it consent to the appellant has submitted that. Even though if it is assumed that the attendant registers maintained by the secretary of the society are missing. As per section 80, 1 in bracket 1, again bracket Roman I. Every cooperative society is required to keep in its head office a list of members, their fulfillment of responsibilities over the previous financial year, and their eligibility to exercise their rights for the current 12 months period. The said record is to be updated within 60 days of closure of the cooperative year. And from that record, it can be ascertained whether the respondent number 10 to 19 have attended the meetings of the cooperative society for the relevant period, in the relevant period. Stop. Have attended in the relevant period or have not attended the said meetings. Stop. And then council has submitted that the granted single judge as well as the registrar has not taken note of the said said situation while passing the interview orders. Stop. Learned counsel for the cooperative department has submitted that he has to ascertain whether such record is maintained or not from the department, and for that he placed some time to complete. He placed some time from time paid for is granted. This matter on Monday.
My lord, can it be on 30th, my lord? I will not be available on Monday. On 30, my lord, 30.
13th.
Yeah, Wednesday.
Three zero. Okay. 30th of October. 30th of October 2024. In the meantime, status quo as exists today shall be made.
Obliged, deeply obliged.
Till next stage.
But yes, because it's the point.
Item 32.
Yes, sir.
Yeah, 250.
May I please? My lord, I received a letter from the judicial department, my lord. They said, my lord, my lord, may I place this letter?
What they said,
My lord, they say, my lord, the judicial department is not, my lord, necessary party in this proceeding. They said, my lord, the legislative department and social justice and empowerment is the concerned department.
this technicalities, you are from the state.
My lord.
File reply on behalf of whichever the department is. This department is not the party. These departments are different from the government or what?
No,
They are
my lord,
under the government. File reply. What's this?
just, my lord, I have received this letter, that information I have, my lord. from the report is-
Please don't show such type of.
On the last
Ask
of
them.
it,
My lord.
on the last of it should also be asked these things. But in this case, the advocate general is required to be served a notice, my lord.
Yeah.
Advocate general. Because we have assailed, challenged the validity of this act, my lord.
Should be advocate general has to appear in the.
Hmm.
Enactment, if enactment is under challenge.
My lord.
you have to- Yeah.
Miller, during interim, I have to pray for an interim order. On the next date, your lordship may consider it.
Interim order will see to it.
There is an order.
Mr. N.K. Sharma put in appearance on behalf of the respondent number 3 to 6. The respondent number 1 and 2. 1, 2 and 7 are also represented through advocates. In this writ petition, the petitioners have challenged the validity of the Assam Section 3 of the Assam State Commission for Safai Karmcharis Act 2023, as well as the notification dated 7th of March 2024, issued by the Department of Social Justice and Empowerment of Government of Assam, whereby Assam State Commission for Safai Karmchari was constituted. Would stop. Since the validity of a state act is under since the validity of a provision of the state act is under challenge, we deem it appropriate to request the Advocate General of the state of Assam to appear on behalf of the state before on behalf of the state. Hence, a petition copy of the petition is supplied to Mr. D. Sekyal and Advocate General by the counsel for the petitioner. Within a period of 1 week, you supply the copy to the Advocate General, to the office of the Advocate General within a period of 1 week. Reply to the petition to be filed on behalf of the state. Combined reply to be filed on behalf of all the respondents within a period of 3 weeks thereafter.
The lordship may kindly fix the date, any day. Otherwise, it will be very difficult to get the matter listed.
December. List on 12th of December.
But I am appealing for response number 3 to 6, my lord.
Private respondent.
Private response.
Private, 3 to 6.
Yeah.
It was recorded Mr. N.K. Sharma, something like that, 8K that.
reply on behalf of the state, state respondent. Not on behalf of all the respondents.
Respondent one and two.
Much.
Yes.
Item 33.
You file any application before the?
No, Lord, I have already spoken to the petitioner, petitioner's family, my lord, but it will be difficult for them to approach the Supreme Court at this stage, my lord.
We have already sought
Yes, my lord.
clarification. and,
But there is-
our
petition is also pending, madam.
Our hands are also tied.
Yes,
in
Lord.
the-
Let it remain pending, my lord. There is no other way.
What's the next date?
Next date, my lord, in before no date has been specifiedly taken, my lord. But our application, my lord, it is pending. If it was sent by the Honorable High Court, our High Court, my lord, it is pending. Last it was posted on my lord 5/8.
Yeah.
Last posted on 5/8, my lord, before I paid for it.
5/8 के बाद में there is no file.
Yeah, after my lord, no, not yet listed, my lord.
पूरा direction management.
Just after 3 weeks.
My lord.
There, any other social organization or something should approach, even though if they, poor, these, petitioners may not be able to approach, but,
I was informed that the government of Manipur, they have approached the Supreme Court for some certain clarifications. Because 27 cases have been transferred to Assam. And now during last 1 year, more than 3,000 cases have been registered and all the cases have been registered with CBI, my lord. Whether regarding this 3,000, those separate cases, whether it will be tried there or it will be tried in Assam, they've
already sought this.
most probably they have approached the Supreme Court on that.
Hope for the good.
Item 36.
Yeah, that's good.
Please give an option. My lord, of course, I must concede. Well, of course, I must concede the fellow had a drinking habit. I'm not on that.
What you are?
He used to consume liquor, but when and when, I'm not on that.
He used to consume liquor.
Yeah,
or
absolutely.
He used to only consume liquor.
No, I'm not on
Not
that.
with food.
Therefore, but I'm not on that part. He was promoted in November 2018.
Physically not promoted.
No, I'm not on that either. With effect from July, one part not taken into consideration, the other, the sanctity of a show cause notice. When they show caused me, I replied. And the authorities in the administrative level and also in the Armed Force Tribunal only took
Four penalty. Every time the same charge.
my lordships, they only
And
took
even
note
on
of
duty, you went on.
very well.
Fun.
I still bow down, my lord.
found that we were lying in a garden or something,
My
some
lord,
area. What is it?
well, absolutely what has fallen from your lordship ought to have been taken into consideration and weighed against me. They did not do that. They totally ignored and skipped that. That is an error of law. May I just indicate, my lord? Show cause notice at page 17. They did not consider my reply. I take it to that extreme, my lord. They did not consider my reply at
What
all.
is your reply? You just, yeah, so, give us give reply to us.
My lord takes,
We'll consider it here only. What is your reply?
I get a chance there. my lord.
What?
I get a forum there.
What would be the
They did
reply
not even
to
take into consideration.
What
They
is the
skipped
reply
it.
to the show cause notice? We are granting you opportunity to, yes, justify your action.
Well, I
of,
can,
having all.
well, I
these
can
fun.
genuinely read out, my lord, what is there. But what I'm on is that I lose a forum. Let them consider my reply, madam. At least take a view.
Satisfy us, we'll grant you every relief. In that case, they'll rule the forum.
I can try. Page 19, my lord. 19.
19.
19.
Sometimes.
This is, I
What's
skipped,
your explanation to that?
no, I skipped this moment. I come to 21. These were never taken into consideration.
What is this?
A,
Yeah.
first case, 4th November 16. False apparent on the face of the charge sheet itself that I was under influence of liquor while on duty, whereas the actual fact is this, that on that day, neither I was on night duty nor I was detailed for the night shift, as I was only detailed for the morning shift. And accordingly, I had performed my morning shift duties even away from the duty place. Can be noticed from the charge sheet itself that I did not enter inside the technical area itself and came back to my billet. Otherwise, if I had been detailed for the night duty, then the charge sheet would have been raised for my absence from the night duty. And also during the charge trial, neither I had been asked to say something in my defense, nor I had any knowledge to say something in my defense without the permission of the CEO. Thus, it's a case of violation of basic principle or the alternate part of natural justice. Hence, I request Your Honor to kindly set aside the prejudice judgment and the punishment entry of my sheet roll may be please expunged with immediate effects to save the proper justice in the extreme organization. He denies and says on duty he was not there. Number 2, second case, 24th May 17. While I was under Module 2 course MTI AFS Tribunal on 6 March 17 to 26 August 17, display of my basic phone became unserviceable, and for repair of the same during afternoon on 24th May 18, duly authorized booked out from MGR, I went to repair shop of Tambaram Market, where he said it would take 2 to 3 hours. Further, after waiting for 2 to 3 hours, when he said some more time would be taken, I went to the authorized liquor shop and took 1 beer and returned to the repair shop. However, still my phone was under repair. Subsequently, when I asked why this much delay, then he said, I've sent a person to bring a new display from the main market to replace.
Instead of.
That's all.
You went there on the shop and.
No, whatever he says about anything. But he's so fair. He says he was hungry and therefore it acted a little bit higher. He's so fair. What I am on is that I use a forum if they do not consider me. Lord. Let them take a view. It's not my prejudice is there. You show cause me, do not consider my reply at all. To that extent, and what they considered, the consideration of the authorities, if Lordship takes up page 33, this is how they consider my reply, At 34, he's an earning member, his marriage is planned. I don't know from where they get that. He's requested his case may be considered sympathetically. He's a law-abiding citizen, hails from a remote village where employment of youth is minimal. This is not my reply. This is a precursor to that. And then I have my detailed reply. Let him consider, Somehow he managed to say it so far, considered for promotion also.
That these 4 instances you are saying, you were punished on those 4 instances that has been finalized. Now the latest instance, and you were concerned that any other incident, any further incident would call for the dismissal from service.
My Lordships, dismissal is a thing when a man gets out of the job. What I say is that kindly consider my reply before you shut me out of the job. Some liberty, because this is the situation, and they also consider favorably. They gave me promotion also.
Counsel for the party, deem it appropriate to admit this writ of it, admit, put up in due course.
Grateful.
Item 37 and 38.
May please, Your Lordship. Lordship, regarding contempt matter, item 38, the area salary has already been released on 26th September, Lordship.
That is there.
Yes.
So we can close the contempt.
My lord,
Maybe
there is a rider minute.
Yeah.
Our dues were for this entire period, it was 58 lakhs and all. Whereas we have been paid 18 lakhs has been deducted.
Why?
I don't know.
And deduct for
So, my lord, if your lordship wants to close the matter, that aspect may be kept open, my lord, so that if they by the end of the financial year, they do not, adjust this amount, then liberty may be given us to my lord.
18 lakhs, why they have deducted that?
They have deducted, my lord.
58 lakhs were due.
By their own showing, my lord, 58 lakhs, 85,504 was payable, of which 18 lakhs, 36,240 has been deducted.
If there's something, it will be adjusted during the end of the current financial year, Lordship. Lordship, it is deducted for GPF, ECHI, these are included here.
Why it has been directed?
I think if my learned friend seeks that clarification, my lord, that will be better, my lord.
You just clarify why you have deducted. If it is permissible under GPF or something.
Yes,
else, I think it's okay. No problem.
I have to take instruction of them. Moreover, my leading counsel is bedridden due to fracture of his leg.
My friend Abha Bhattacharya, she had an, fracture in the leg.
Bedridden. Lordship.
Okay, इसमें contempt नहीं है। लगने concept बता respondent petition contempt then concept of the petitioner must be taken to its concept it's submitted that the amount of how much of that has been paid?
My lord, 40 lakhs and odd has been paid.
40
and 18 lakhs and odd has been deducted.
That amount has already been paid to the appellant, to the petitioner from the dues. Over rupees 18 lakhs have been deducted, for which no clarification has been submitted by the contemnants. Which of learned counsel appearing for the contemnants submitted that the contemnants will clarify about the deductions made while making dues, while clearing the dues due to the petitioner. He placed some time that time frame for his granted. He placed some time frame for his granted, at least 2 weeks.
Well,
Rate of appeal be correct, the writ petition be accepted.
Item 39.
This is against the order of the CAT, what even? The fact in a nutshell of the case is that the applicant had applied for a post of the malaria and health and malaria officer gate 3. And after my written examination, he got the same cutoff mark that of the last standby candidate. And he was not shortlisted in the standby list also. So he submitted an RTI application to know his status. It page 113, reply was given to him, page 113 of my petition. That reply, my lord, they have stated, reply number 1, out of 22 candidates called in document verification, 12 candidates were called as per the vacancy.
113.
113.
RTA online enter registration number 123. Out of 22, these 12 candidates were called for.
And another 10 candidates are extra candidates. Then, my lord, total 5 candidates were rejected at the time of document verification, 2 unreserved candidates and 1 unreserved PWBD candidate, physically challenged candidate. That I belong to unreserved category. Since 2 were rejected, since I have secured the same marks of the last standby candidates.
But you were not even placed in the waiting list.
Yes. That is the case. That is the case that by the
You are not even placed in the waiting list. How you can be called?
That is what, my lord, my submission is that I submitted an MA before the tribunal for amendment of my prayer. For amendment of the prayer to my lord, review the standby list also. Because securing the same mark of the last.
They were senior to you.
That is by age, by age.
Therefore, they were placed in
Yes, this is the case in a nutshell.
Ultimately, if you are not even placed in the merit list, you can't say that since 2 persons who are not eligible for appointment, they have been ousted. Therefore, you may be included in the. That is.
Yes, Lordship is correct. Lordship is correct. Now, my lord, since I secured the last mark, the same mark of the last standby candidates, that is why my prayer was there in the MA, you revised it because securing the same marks, there are vacancies, 2 persons, unreserved persons remain unfilled. Yes. Yes, yes. Mhm.
Your demand once. You should have challenged that action when you were not placed in the waiting list even.
My lord, that is what my MA, I made an amendment.
Even though if MA, how that relief can be
My
granted?
lord, then I'm coming to page 125 of the relevant instruction.
Yeah.
Page 124.
124.
There's a provision, this is a circular of 2020. There is a provision to the chairpersons all railway recruitment boards, review of standby list from 50% of vacancy and publishing of standby list. Boards letter dated so and so declared directly, my lord, I am coming to page 125, Roman 5.
Yeah.
However, even after calling of 50% additional standby candidates for document verification as mentioned in para 1 above, if there is a shortfall in making the final result as per the para 2 above, the RRB shall conduct second DV, document verification, which will be equal to 1.5 times the number of shortfall in the community category wise notified vacancies being by the below the merit list to make good shortfall. This circular was also not be taken care by the tribunal. And there is no reply on this, my lord, by the railway also. Then para 6, my lord, in case RRB feels that there is a need to go further down in view of the very less number of candidates available in the standby list, or there is insufficient number of candidates in standby list to provide replacement panel, they may conduct another DV as per para 5 above. My humble prayer is that from RTA reply, I have come to know that 2 unreserved candidates did not qualify document verification. So 2 remain vacancy remain. And on that, my lord, there is no reply by the railway. And on this, the revision of the review of the standby list in page 125, there is no reply of the railway also.
That's the point.
This is my lord short my case short. So my lord, very unfortunate.
Lordship, the page 124, 24 is in respect of CEN, that is Central Employment Notification of 2018. And ours, we are concerned with 2019. And for that, the Railway Board has issued the Lordship, page 69. This is of 2022. And the CEN is of 2 of 2019. So that my friend has referred that will not be applicable. The guideline given in this Lordship, page 71, page 69.
Yeah, 2022.
22. And this is in respect of CEN, that is Central Employment Notification, 2 of 19. We are concerned with 2 of 19. And which my friend was referring, that was of 18. 2018, Lordship.
He was referring to 2022.
Yes.
20.
He is referring 2020. And the guideline, let's pay clause number 4, Lordship. It says there's only from the standby candidate, and we have standby candidate included 1.5%, 1.5 times. That is 15 posts were meant for the RRB Guwahati. We have made a list of 22. That is 15 plus 50%, 7, it's 22. And all 22 has been accommodated, Lordship. And he is not even in the standby list. That is, Lordship, what the tribunal has even finding, Lordship. Is clause 4, subclause 4 says no further document verification to be done if the 1.5 times has been achieved, Lordship. Clause 4, subclause 4.
And he has challenged that this,
If he challenged that,
he has challenged that.
not directly, but he said should not be made applicable to him.
The tribunal has recorded a finding of this effect, that on one hand, he is seeking
Benefit of that
benefit of
circular.
this, and on the other hand,
One
he is
time.
saying that it should be.
So appropriate and reprobate cannot be done at the same time. Also.
Page 69, my lord, I am reading Roman 2, what my learned friend relied on. Page 69, Roman 2, subpara Roman 2.
Yeah.
After exhausting the standby stroke waitlisted candidates available with catering RRB, if there is requirement in journal review, the same shall be met from other RRBs catering the requirement of the journal that journal review. Meaning thereby, after exhaustion of the standby, in my case, my standby is also exhausted. And I am the man, very unfortunate man, who got the same marks of the last standby candidate. So why, my lord, I will not get the benefit of these also? They will bring from another. They have issued the circular to bring for another RRB, keeping mutual that the last standby candidate is seeking the same. By virtue of my age, I have not got the appointment, although their stand is that after exhausting the shortlist, standby list, waitlist candidate, you can bring from another RRB.
Close for all.
My, okay.
Item 40.
May I please, your lordship, lordship matter relates to non-payment of rental compensation. Here the petitioner's lands were lordship in fact acquired, and they have received the acquisition compensation. And their claim before the single judge was that since they were in occupation of the land since 1966, so the rental compensation has to be paid. However, they have limited their submission to the date from which the land settlement certificate has been issued. Now, the stand taken by the union before the single judge, if I may take your lordship to the affidavit filed by on behalf of the Union of India before the learned single judge, lordship page 79. And I may take your lordship to the relevant page. Relevant paragraph would be paragraph 5. Paragraph 5, page 80. And the relevant portion will be at page 81. 1, 2, 3, 4, 5.
Yes.
7th line from top, lordship. If I may read from the first line itself.
Yeah.
The land was exchanged between the PWD and PWD then located at Lungwan and Assam Rifles located near DC office Lunglai. Compensation was paid by the Mizoram government amounting to 14.95 crores to the genuine landowners for the period from 1966 to 1986, which was released by the government of India according to the peace accord signed between the parties. For Lungwan land, in addition to the part of above amount, the genuine landowners have been paid from time to time rupees 3 crores 85 lakhs and odd and rupees 21 lakhs 97,000 so. Now, we have paid land compensation, this rental compensation for the land that we were in occupation. Now, it is not for us to give the rental compensation individually, lordship. We give it to the state government will distribute it. Now, if these people have not got, let us say that these people were genuine landholders. If they were genuine landholders, we have disbursed some amount.
Not to the landowners, to the state government.
To the state government, then the state government will give it. Now, what amount has been disbursed, we do not know. For us, lordship, Our stand is we have given some amount. It may be a bit less or it may be some bit more. But it cannot be a case that we have not paid any rental compensation at all. So that position has to be clarified. And in fact, Lordship, this, in spite of the notice being published, nobody has appeared for the private respondents.
And the stand of the government of Mizoram.
Mizoram also, Lordship, they are not here. They are parties here, Lordship.
They are not parties.
They are parties, Lordship. And so far as Lordship, occupation of land from 1966 is concerned, Lordship, I may just inform your Lordship that the Assam Rifles is the oldest paramilitary force, and they were there since 1890. And thereafter, when the insurgency started, Lordship, their post was attacked, and their land they were occupying, that was exchanged with the Department of PWD. So that is how we came into occupation of that part of the land from 1966 onwards, which they say is their land. But we have got it from the PWD. And the learned single judge Lordship, although Lordship, there was some delay, we had taken a ground of delay. Lordship, the learned single judge has overruled that. I would not go into that, Lordship. Only part is that the penultimate paragraph, Lordship, at page 115, paragraph 15 and 16.
But this land certificates were issued when?
Lordship, the dates are mentioned in the judgment, Lordship. If your Lordship will come to page
11, 1987, 90.
Yes, this,
93, 88, 94, 2011.
even
86,
now,
112, 86.
now these lands which we were under occupation, this was declared to be a protected land.
These
Now,
in fact, land certificates were issued to them on the
After-
various dates, and the court has simply said, till the acquisition,
Yes,
till they acquired, this acquisition took place, pay them the rent.
that is okay, Lordship.
And you have simply in your, this affidavit, you have said, 1966 to 86, you have released some rental amount. But they are not claiming from 86, they are saying, since 86 to till acquisition has taken place, tab tak ka to rent aap denge na, you have to pay that.
Lordship will kindly consider this land which we were in occupation, which they say was our land. They said it is our land, you have occupied it.
Yeah.
And they have brought in some land certificates, which states from 1987 onwards, that
86
this has been issued. Now, how come a land certificate, land settlement certificate will be issued on a land which we are in occupation, Lordship, and that is a protected
Should
land?
have challenged that land certificate. And in fact, the award of 1/2016,
Yes,
their ownership was proved. The award was passed while the acquisition land was acquired,
Lordship.
and land was acquired from them. Compensation was paid to them for the said acquisition.
Lordship,
Now, if they were in possession from 1986 or 87,
Lordship,
till the acquisition is there, they have simply said to pay them the rent. What's wrong in that? This is what the case is, sir.
yes, Lordship, that,
That land certificate, on the basis of these land certificates, they were paid compensation in lieu of acquisition. How can
Lordship.
you say that these are not the owners only on the basis of land certificate?
Lordship, I get your Lordship.
This is not the, or land single, they simply said, since the date they are in possession of the land certificate 66, the London single judge has said no. And the counsel for the petitioners have also said, okay, don't give us from 66, but from the date when we were, these land passes were issued to them. On these very land passes, on the basis of these very land passes, acquisition compensation was granted to them.
That I cannot deny, Lordship. That I cannot deny, Lordship.
What remains, sir?
Lordship. Lordship, will you make an observation on that, Lordship?
What observation?
That it is from the date of the land certificate, Lordship.
That is the London single judge has simply said. This is what the
Yes,
London
yes.
single judge has said. There is a question of making an observation. Para 15,
Yes, yes, Lordship.
collector should determine the rent, use of land defining so and so. This court finally issued, not hit by the delay. Also award dated writ petition. However, in view of the stand taken by the council, they are limiting their claim payment only from the date of a land certificate. The respondent are directed to pay the petitioner from the date of issuance of petitioner land certificates till the acquisition of their land. That is 2/6/2016.
16. Lordship,
This is what the
I bow down before your Lordship, Lordship. Vice Chancellor.
close for all.
I got it, sir.
This is what the-
And there are, Lordship, constraints for filing these.
Yes.
For hearing, item 47.
The petition filed by the department against the other partner and CSEC, whereby the charge sheet was passed. If the petitioner was the officer of the department,
while he was working with the commissioner affiliates, he passed some order. It was against the norms of the department. During the pendency, although he is retired, but Lordship, the learned tribunal set aside the charge sheet. So the judgment is at page 111. Then we come to page 119, Lordship, paragraph 12. Very good. We have examined the instant case, taking into account the similar cases cited above, as brought out in the foregoing paras. The charge sheet is issued essentially on the premises that the applicant must have accepted certain consideration for having cleared such a heavy amount. This is found to be based on suspicious and premises and not acceptable in the eye of law, as brought out in the foregoing paras. Though the applicant may not be immune from disciplinary proceeding in discharging his duty in his capacity of quasi-judicial nature, the basis for initiating the disciplinary proceeding as stated by the respondent that his decision was set aside by the higher authority, that is IPAT, is not acceptable. Basis for inflicting disciplinary proceeding against the applicant, as the system would not be able to function if this is done in a routine manner. Keeping in view of the above also, in conformity with the decision of coordinate bench of CAT Supra, we find that the charge sheet initiated by the respondent authority by their memorandum dated 27/12/2000 is not maintainable and liable to be set aside. Accordingly, memorandum dated is hereby set aside.
Lordship, I am, page 19 is the charge memo, Lord. My, two
Page
contention.
19.
19. An article of charge is at page 21. Lord.
Yeah. Read the charges.
Lordship, yes. There is only one chart.
Read the chart.
Lordship. Page 21, article 1. The said Sri Vinay Kumar, so presently posted as Principal Commissioner of Income Tax, Guwahati, held the additional charge of Commissioner of Income Tax Appeals, 8, Kolkata, for a brief period from 11/6/2008 to 30/7/2008. During this period, Sri Vinay Kumar had deleted in addition of rupees 120.55 crores in appeal disposed of by him in the matter of 3 days. The same addition was made by the assessing officer in case of so-and-so for the assessment of 2005-6 after thorough investigation in which the assessing officer had established that the commission payment to the tune of rupees 120.55 crores by the SSC to local commissioner agents for same transaction. The case was also selected by the charge CIT as one among base assessment order under his charge. The concerned assessing officer who was present during the course of hearing before the CIT appeal was handed over a copy of the argument filed by the SCC. However, the additions made were deleted by Sri Vinay Kumar, CIP appeals within 3 days of first hearing in the case without bringing in any additional facts and without waiting for the report from the assessing officer. Thus, Sri Vinay Kumar deleted the entire edition under consideration based on wrong appreciation of facts by giving only a token opportunity to assessing officer and passing the order in haste. By the aforesaid act of omission and commission, Sri Vinay Kumar has failed to maintain absolute integrity and thus exhibited conduct unbecoming the government servant in violation of Rule 311, 312, 313 of the CCS Conduct Rule 1964. Lordship, he was given 10 days time to file his reply, but without filing reply, it was to that CAT, and the learned CAT passed the order passing the charge sheet. On the ground.
Say misconduct.
Yes, Lordship.
It's too much.
No, Lordship, here.
Any authority, appellate authority, having constitutional powers, if deleted any entry or whatever it may be, pass a particular order.
No, Lordship, here the question of honesty and integrity is involved.
Where is the charge that you have taken so much of bribe or money from that person and therefore you are not, where is that?
No, Lordship.
Simply because you have passed an order in haste and therefore this misconduct is there.
Lordship, here question of integrity and honesty is involved.
Sir, where is the doubt about integrity and honesty?
Because Lordship,
in one case in his career, if he has decided he is dishonest.
For a brief period, he was given additional charge.
Whatever it may be, so either show us any circular or anything black and white that if you are giving an additional charge, you are not supposed to decide any case finally. You have to discharge routine works. Bata de.
No, thereafter he was removed from his additional charge.
Whatever it may be, sir. Whatever it may be, you just show us any instructions from the department that if an officer is holding this additional charge, he is not supposed to decide the cases finally. Show us.
Despite
that, if he has done so, certainly you have a point.
No, Lordship, my second question about Lordship, whether tribunal can set aside a charge sheet.
Tomorrow, day in and day out, we are giving charge of the additional charge to the judicial officer of one court to another court. Suppose he decides a case of court of which he was holding the charge, will issue a charge sheet. Why you have decided?
No, Lordship, that is quite different in my humble.
This is the only thing and nothing else.
Lordship, I am relying on few judgments. Lordship, may consider and.
Few judgments on this point?
Yes, sir.
Show us.
Yes.
If a person, if a judicial authority has decided a case and granted some relief to other party, it amounts to misconduct. Show us.
No, Lordship, not on that point. Lordship, judicial authority has to maintain their integrity.
No doubt about that. Who questioned his integrity? Where is the question of integrity that you have passed this order due to some extraneous considerations? Where is the charge?
Lordship, statement of petition that is clear where we stated in page 22 to 26. Lordship.
Yeah, read. Is there any whisper about it? That yes, you have taken money or you are in contact with so and so person and therefore your integrity is doubtful. ACRs may, is there any entry that integrity doubtful?
That I cannot go. That I cannot say it this week. In the meantime, he has retired during the pendency of the.
Thereafter, they issued the charge. This is too much.
During
what he has done this matter in the very in a hasty manner, decided the matter in a hasty manner in 2008.
Yes, sir.
And when this order was reversed in the 2016, then you have served in a charge sheet. Why you have not served in the charge sheet then and there? In 2008 itself?
Lordship, because Lordship, the proceeding was.
Why? But he is misconducted. He misconducted in the year 2008 itself. Why you have waited for 16 years? And suppose if this income tax tribunal order reversed by the High Court, then what would happen? you'll issue a charge sheet to income tax, tribunal,
No, that
presiding officer of the tribunal. Since your order has been reversed by the High
No,
Court,
no.
therefore you are also, your integrity is doubtful.
Tribunal is not within the jurisdiction of the income tax officer, Lord, because it is a civil, it is a judicial.
That's very, very strange.
Lordship, consider, I am placing few judgment, Lordship, consider.
Nothing, there is no question of, then be ready for costs.
Lordship,
Give us the, yes, show us the
2006
judgment.
2000
Be ready for heavy costs.
Lordship, I cannot object to that, Lordship, if Lordship feels that.
No,
it is
no, you are so adamant that
No,
a
Lordship,
person, this, Mr.
my-
Kayan, please try to understand.
Question of my Adam.
You
I am just submitting for consideration,
try to
Lordship.
browbeating this, nothing else. Then who is going to decide any appeal
No, Lordship.
in favor of the SSC? Which officer is going to decide any appeal in favor of the SSC, even in a genuine case also?
No, Lordship, in genuine cases, department is not proceeding. as a
You are,
civil court.
this is malified and nothing else.
No, Lordship, here, Lordship, please
Two
proceed.
2008 order, you have served him a charge sheet in 2017 when his order was reversed. Why this order was so bad? Why it was not reversed immediately by the tribunal?
No, Lordship, appeal was preferred. Then the SEC preferred appeal. Then it went to the Calcutta High Court. Calcutta High Court passed order in favor of the department.
Whatever it may be. That's altogether different thing.
I'm placing one judgment, Lordship, consider and
Okay. Be
2006
ready for that other consequences also.
Lordship,
Show us the judgment. Yeah.
2006 5 SEC page, paragraph 5, page 680. Two thousand six SEC, page 680, paragraph 5, Lordship. Union of India versus Dulika. The name of the party is Union of India versus Dulika.
Yeah.
I'm reading paragraph 5, Lord. The law on the subject was considered in extenso in 3 judges bench decision of Union of India versus K.K. Dhawan, wherein it has been noted that view that no disciplinary action could be initiated against an officer in respect of judicial or quasi-judicial functions was wrong. It was further said that the officer who exercised judicial or quasi-judicial powers acting negligently or recklessly could be proceeded against by way of disciplinary action. The court listed 6 instances when such action could be taken. Paragraph 21E, when the officer has acted in a manner as would reflect on his reputation of integrity or good faith or devotion to duty, that there is a prima facie material to show recklessness or misconduct in discharging his duty. P, it has acted in a manner which is unbecoming a government servant. Then 4, it has acted negligently or that he omitted the prescribed conditions which are essential for exercise of statutory power. 5, if he has acted in order to unduly favor a party. If he had been acquitted by corrupt motive, however small, the bribe may be because the Lord Cox said that long ago, though the bribe may be small, yet small is great.
So which is which head is case is covered?
2, Lordship.
True.
If there is a prima facie material to show recklessness or misconduct in discharge of his duty.
So recklessness and misconduct you find only when the order was reversed by the appellate court.
No, Lordship, he passed the order within 2 days and with hasty.
So he acted recklessly and this whatever you are saying, recklessness and misconduct. So he committed misconduct in the year 2008. And you first time you found when this order was reversed, then you found that he acted recklessly in 2008. After 8 years, you realize this.
That is there.
Be ready for what?
Then regarding Lordship, no, Lordship, I'm
be ready for cost now.
Lordship, then Lordship, another 2006.
The cost would be enhanced again.
No, Lordship, I'm not.
You are not bothering about that. Cost is to pay by the state government.
No, Lordship.
The private party Any cost,
Because
that
Lordship,
is
the
for the private party to
Lordship
consider.
department preferred this writ petition.
When we are asking for cost, you are getting one more judgment, three
No,
more
no, Lordship,
judgments. Okay, give us.
Lordship, the department preferred this writ petition only because there are a number of instances in the department.
A number of instances, then immediately take action. This action that is, since your order is reversed, therefore we are taking action. This can't be permitted, sir. How can you do it?
That point is there.
How can you do it, sir?
Lordship may consider whether charge sheet can be set aside by the.
It can be set aside in such circumstances, certainly. Order is there. Be ready for cost.
Lordship.
Item 49.
My lord, this is a case, my lord. I filed an SPC application before the tribunal. Service dismissed. And tribunal limitation. Yes, that is a ground for limitation, my lord. And different court has taken different views. So I have your lordship for your kind perusal. I can give you citation of all the judgment. Or it will be easier for you if you go through all the judgment. So many judgment I have annexed. This will be good for you, my lordship. Now, my lord, what happened actually that I will go one after another judgment. First of all, there are two acts. There is Surface Act and Redby Act. Recovery debt. In Recovery debt, Surface Act, Securitization and Reconstruction Financial Assets Act Enforcement Act 2002. And other one is Recovery of Debt and Bankruptcy Act. Okay. So both the first act was which was enacted is Recovery of Debt and Bankruptcy Act. Later on it was enacted Surface Act. That action has to be taken by the bank, Surface Act. And the recovery debt is the matter which is adjudicated by the tribunal. In Recovery of Debt Tribunal Act, my lord, there is a provisions of limitation. Specific provision is there. And Surface, when the law was enacted, that provision was omitted. That there you can't get any relief. Bank will get a relief, but the other party will not get any relief. And there's in my case, there's delay only 19 days. Bank is getting relief from how the bank will get the relief. No. The limitation, they can take the benefit of this limitation act. The bank can take and the private party can't take. Yes, my lord. No, in Surface Act. In Surface Act, bank will not get any relief because bank is not filing anything. What the parties have to file an appeal. And it's true. Yeah. No, my lord.
Very important benefit for the power.
You relied on certain, you're placed on record certain judgments in many of the high courts have.
Yes.
But the Calcutta High Court has.
I only negated by the view.
And it's, yes, what judgment for?
And my lord, what happened? I just can do. Bala, if you go, lordship, go to the Balasha judgment. Yes, first judgment. That is very important because the Supreme Court come to conclusions that the people who is aggrieved by the order passed by the tribunal, there is no provision for limitation. In the appeal, they can go for, if you file an appeal, that appeal will be condoned. That has to be condoned.
That 18, the 18
282, yes. If the 18 has to, if it is condoned, then why the same power has not been given to the tribunal to condemn the delay?
That is what.
And then that's, and that,
George.
yes, George, yes, similarly worded.
That is
Yes,
pending.
and if you go through the Service Act, everybody it is written that whenever you file an, whenever it, if lordship go through deeply the Service Act, there is provisions that, yes, chorus regulated is there.
What we are saying, that we'll go through all these judgments.
Yes, my lord. Then
the judgments on which you are placing reliance.
So lordship, before
That
I
is
place,
Murdia, main to Murdia.
no, or there are several other judgments. Lordship. Well, lordship, may I please the facts first?
Facts. Plain and simple.
Why
That
this,
is the-
lordship,
the
just
tribunal
may I
has the-
please the settled position of law? Just, I'll take your lordship just few minutes.
Yeah.
This lordship, the Surfacy Act, if your lordship comes to pay section 17 for a moment, I'll take just few minutes, lordship. Why this act was incorporated after the recovery of debts and bankruptcy act? The purpose behind the enactment of this act was speedy recovery of the enforcement of the security interest. So for the bank is secure.
Avoid the.
Now, lordship, I will just play, I'll come to your lordship. Now let us come to section 17.
Yeah.
For a moment, I'll take your lordship to section 17. May I read, lordship? Any person, including a borrower. Now, lordship, just before I submit, in the Surfacy Act, your lordship, each and every provision has a specific limitation, the time limit. The legislature, the intention of this act is specific time limit for each and every act. Even if your lordship sees how the measures has to be taken by the bank, that is also specified in the Surface Act, and that is also a time limit. Suppose say for example, 13-2 notice. In the 13-2 notice, we have to give specific time limit of 60 days. Then the 13-4, there is symbolic position. In the symbolic position, the moment we publish take symbolic position, that has to be published in the newspaper within a period of 7 days. That is prescribed. So every act is so what is still time bound. So also in section 17. Section 17 application has to be disposed of within a period of 60 days. That is also written. And if it is not disposed within a period of 60 days, within maximum period is 4 months. I'm coming to that. Any person, including a borrower, aggrieved by any measures referred to section 4 of section 13 taken by the secured creditor or his authorized officer under this chapter may make application along with such fee. Now, your lordship, fee. In the civil code, we have to pay the court fee. Here, the application fee. As may be prescribed. It is prescribed in the rules to the Debts Recovery Tribunal having jurisdiction in the matter within 45 days from the date of which such measures has been taken. Specific, lordship. There is no provision as such. Now, lordship will come to section 1A. Why I'm taking your lordship's decision to draw your lordship's attention, the original jurisdiction of the tribunal. If lordship, this Surfacy Act debars the civil jurisdiction of the court, as per section 34 of the Surfacy Act. The jurisdiction of the civil court is barred. Now, if the jurisdiction of the civil court is barred, a person aggrieved by the Surfacy action has to approach the Debts Recovery Tribunal. Otherwise, he could have filed a civil suit.
Yes.
Now, lordship will come to section 1A. An application under section 1, subsection 1 shall be filed before the Debts Recovery Tribunal within the local limits of which jurisdiction first, the cause of action follows in palm. That is what we follow in the civil code. The secured credit is as assets, and the branch or the other office of the bank or the financial institution is maintaining account. Now, lordship, the very section 17 subsection 3 is very important. Mary, if the Debts Recovery Tribunal, after examining the facts and circumstances of the case and evidence, means we can lead evidence before the Debts Recovery Tribunal in an application under section 17, which relates to the original jurisdiction of the court. May I, if I'm clear, lordship, produce by the parties.
View of this subsection 7 of this section 17. Yes, my
Lordship.
lord. That is the thing, my lord. And if we apply the analogy of this Baleshwar Dayal Jaiswal, the delay can be condoned. If the
No.
delay-
No.
How?
I'll try to satisfy
You do
you.
one thing. You just give me the list of this judgments. You submit the copy of the judgments. We'll keep it on next Tuesday and we'll hear you extensively.
Lordship.
We'll go through these judgments.
No, I am giving your lordship my list of judgment.
Compilation,
Yes.
you give us the compilation. We'll read both the judgments, both the judgments, and then we'll hear you.
Okay.
Because this matter, there are many cases
Yes,
of this type.
This requires extensively because that will be a settled law, lordship.
Yeah, that's right.
And if I'm not on the merit of this case, if your lordships comes to the conclusion that delay can be condoned, there will be floodgate in the DRT.
See, it's a delay can be condoned, that doesn't mean that delay has to be condoned. It has to be
No, no,
taken into
if that,
consideration.
there will be a floodgate of so-called petition for
We are not
condonation of delay.
concerned. If the floodgates will be open, then it's okay. If the law says so, it's okay.
Yes,
If the law says the delay can't be condoned, can't be condoned.
lordship, that is the thing.
You have the compilation of the judgments,
Yes, I'll be,
compilation of the judgments.
I'll be giving the printout of judgment.
Print out the judgment. This is also a print out of the
Yes,
judgment.
I'll be giving, yes.
You give it with a chart
Okay, I'll do.
by tomorrow or
Next Tuesday.
next Tuesday.
So can it be at the first list of the hearing? It will take
That
some
is-
time.
That would be listed in the court and
Okay, Or if it's after Diwali also, I have no problem.
January.
After Diwali.
After Diwali, he wants that, he wants that it should be in November.
No, I'm speaking after Diwali just only.
After Diwali.
Yes,
Fifth,
maybe my learned friend is having.
no. Fifth or sixth, yeah, fifth.
5th of November.
Yes.
You just give us the ES2 underneath.
5th of November, lordship. I'll be giving this with the competition.
And if your lordship goes to the interpretation of statute, my lord, the statute says that whenever a new act has been enacted, that is to be followed by old act. The old has some implication over the new act. First act is recovered act. Here everything is there. But in the new act, the refund has to be made because that's why it is said that whatever the section 17 says, 17(7) says, whenever anything happens, if it's not permissible, that will recover tribunal act has to be followed.
Section 17 and this section
22 after
24
limitation
has
act.
been interpreted, lordship.
But no, 22
And
of the
it-
limitation act will cover everything.
Let us.
That has been interpreted,
It's an
well
interesting question.
interpreted in series of
Just,
judgments.
Give us, we'll take some time and go through all these judgments.
Yes, ma'am, yes. That's what
Because
they
it is
after the-
specifically held that it is original jurisdiction. The main question will
Because
like,
it is very important because it will be binding otherwise. It will be binding for Guwahati, Assam, because if it is the law, whatever the judgment is passed, it will be binding for other person who filed an application before the tribunal after.
Yeah, that's it.
Yes, sir.
obliged.